All right, so just a formal welcome to our speakers. So good afternoon from Delhi, and we are very, very privileged to extend a warm welcome to Sir Robin Jacob, our speaker this afternoon, who has kindly agreed to speak on the future of standard essential patent licensing from courts to regulators. I don't think he needs introduction in the echo chambers that we live in, but just for completion's sake. Sir Robin Jacobs has a distinguished career spanning over 40 years as a leading figure in intellectual property law. He has served as a prominent member of the UK's IP Bar, High Court judge, and subsequently as a Lord Justice of Appeal in the Court of Appeal of England and Wales, where he significantly shaped the development of IP law in Europe and beyond. Sir Robin was appointed a Lord Justice of Appeal in 2003. He retired from the court in 2011, and he took up the Sir Hugh Lady Chair in Intellectual Property Law at University College of London, a position which he continues to hold. Just for the people who have joined the webinar, just to provide a context of the talk, the webinar actually was inspired by Sir Robin's paper with the same title, and we choose to keep the same title because this discussion has assumed great importance with various policy proposals now being proposed and discussed in policy circles in India and elsewhere, where SCP licensing, quote unquote, problems have resulted in a call for regulators to step in. Some proposals are based on a cognizable theory of market failure, but these theories are often not backed by empirical evidence and may be resting on questionable assumptions. To just give you a brief background why we are doing this, because at ICRIER we are trying to gather some empirical evidence of the same, in the sense whether or not there is a need for regulation or the markets can operate with courts as their backing. As economists, we know creating efficient markets in technology is challenging, while there is no doubt that maintaining a balance between SCP holders and ensuring access to standardized technology by follow-on innovators is very, very crucial for economies to harness the benefits of this technology. And more so for India, the Indian context comes from the fact that India aspires to be a developed economy by 2047. And innovation-led growth, knowledge economies become very, very central to fulfill this aspiration and ambition. And standards and standard essential patents, therefore, have a crucial role to play when it comes to be a part of a global economy and integrated into the innovation system, global economic system. But what is the institutional path to achieve this balance, and how to create these efficient markets of technology? That requires a lot of law and economics interface. So in this context, the webinar seeks to answer the following questions. Can reliance be based on private ordering and courts to achieve this balance? And by the way, this was our first research question in our policy brief, which we had published way back in December, without, frankly speaking, even being through the extensive literature, which is now available. And what is a proper institutional response to achieve this balance? Should licensing be left to the market or guided by regulatory frameworks? Can regulatory responses create efficient markets for technology? Or will they be blunt instruments and impose a public ordering that may compromise the efficiencies of the current system? Will the markets and other mechanisms be able to offer solutions short of regulations to the sources of frictions in these markets, and what could those be? So making my task easier is what I envisage to be a rich discussion. We are joined by Dr. Ashish Bhardwaj, my partner at crime since I think 2015, who is the founding dean at the BITS Law School, Mumbai. He was previously a professor and founding director of the Jindal Initiative on Research on Intellectual Property and Competition at OP Jindal Global University. Ashutosh, welcome. He's a partner at Singh & Singh, specializing in patent and competition law litigation. He holds a master's degree in intellectual property law from University College of London. Sneha Jain is a partner at Sai Krishna and Associates. She provides litigation and dispute resolution advice in all branches of IP laws, having particular expertise in cross-border IP litigations and multi-jurisdictional arbitration. Just a brief introductions of myself. I am the moderator of the session. Payal Malik, a visiting professor at ICRIER, a think tank based in Delhi, and our thematic area is digital economy, startups, and innovation. We are hosting this webinar, and I was formerly the advisor and head of economics at the Competition Commission of India for almost a decade between 2012 and 2023. I'm joined by my two colleagues in this project, Aman Sinha, who is an IP practicing lawyer, and Saloni Dadwal, who is a research associate at ICRIER. So welcome to all, and Sir Robin, welcome to you. And the floor is yours. So we would love to hear your views on this topic. Thank you.
Okay, well, my basic message is if it works, why fix it? The standards are pervasive throughout our lives, all sorts of different standards. I mean, we take them for granted, hours and minutes, and they are standards. We fix them every now and then, but they're not commercial standards, although they're important to commerce. You always need a controlling body for standards. The international space people all have various standards they use. Everybody has standards. They became important commercially in the Industrial Revolution. It was a huge invention, actually, to have a standard screw. Some of you may have seen on packets of screws the word Whitworth. He was the man who invented the standard screw, the standard nut and bolt. Otherwise, you made your own each time. Many standards don't need innovation at all, and we're not concerned with them. But some do. And it's innovative standards we're concerned with today. And it is vital to remember that they are innovative standards. They're continuously evolving. I'm going to say a bit more about how the one that matters most has done that. Most of the standards, even the innovative standards, seem to cause no trouble whatever. There were no disputes, or so little disputes that nobody really notices them. It is SEPs for cellular standards which are the ones which matter most. There have been disputes about other standards a bit, but not much. And competition authorities started getting worried about it in the early 10s, when the European Commission took action and forbade people from going to court to sue, which was a gross violation of anything you can possibly think of about the administration of justice. They didn't trust the judges. It was Apple who managed to persuade the European Commission to make an order to that effect against the Korean company whose name simply escapes me. They make my phone. Actually, the regulators have not stood back and watched and looked at the evidence. We have got, particularly with cellular phones, but also anything else, the greatest worldwide cooperative and yet competitive system that's ever been devised. It is astonishing. The patents which are come into play are not any of them dominant. It's not like a drug patent which is really important for one medicine. It's one patent. These are thousands of improvements, bit by bit. And it's worth understanding the system before we start talking about whether it should be regulated. Every one of these systems needs some kind of SSO, standard body. The one that is most matters is the European one for mobile communications, ETSI. I put out a little paper. I don't know if we need the slides, but I put out a little paper with the ETSI rules, which matter. Because first thing to do is to look at the rules.
Should we share that?
If you can, if it works, we can.
Yeah, sure. Is that good, sir?
Yeah, that's it. Very good.
Yeah.
These are the ETSI rules. The first one requires disclosure. Each member, and you have to be a member of ETSI, most of the innovative companies are. Of course, people who are mere users are not members of ETSI. Can we get to the top again? Can we go to the top again?
Yeah, just a minute.
Disclosure of IPRs. Subject clause 4.2, doesn't matter. Each member shall use its reasonable endeavours, particularly during the development of a standard where it participates, to inform ETSI of essential IPRs in a timely fashion. And in particular, a member submitting a technical proposal for a standard shall draw the attention of ETSI to any of that member's IPR which might be essential if that proposal is adopted. So if you're a participating member of ETSI, you must timely disclose your essential IPR. What is an IPR? Well, there's the definition in the next line. Shall mean any IP right conferred by statute law, including applications, therefore. So what happens in the real world is that as soon as a patent application is made, it is disclosed. What does that mean? It means nobody knows what the claims are going to be because it hasn't been examined. It doesn't know whether the patent's ever going to be granted. So that's the first inherent fuzziness. Although it's declared, it may or may not cover the standard that's developed. The next feature is the request for a FRAND commitment. And a FRAND commitment is essentially that a license will be granted for anything which complies with the standard. Now, not all bits of standards are essential in the world, in the real world. Some are, some aren't. Some are vital for all operations, but a number are not. If they're optional features of the standard, if you don't want to put it in your machine, in your phone, you don't have to. So it's essential technically, but not commercially. Again, that word essential, I think, excites regulators as imagining everything is essential. And they don't understand the patent system at all about why there is over-declaration. They think it's something else, some greedy people applying for more than they're entitled to. And it is really important to understand the system. There's a particular form for doing it. And that's enough of this slide. We can get rid of the slide now. That's all you need. But it's the first thing to do is to understand, before you want to regulate, what it is you're trying to regulate. and it is a system which is inherently got fuzziness in it as to whether it's essential. The European Commission got very excited about that, and they have been for years. They want essentiality checks. Well, that's a very rough and ready job, which you can get done, and some companies do get it done, but commercially, and the patent pools require it to be done. But all it tells you is whether the claim covers something within this in the standard as it stands at the time. The next thing is the standards themselves are always changing. Although we talk about 2G, 3G, 4G, 5G, as though they're each is a particular edifice. It's not. There are versions. They get versions every year, or more often. Sometimes something drops out of a standard, or something is brought into it, or added to. So that's all on the move as well. The number of essentials patents is on the move. On the whole, it's been increasing over the years. If you want count patents, but again, that's a complicated business, because in some places you can put more things in one patent. In other cases, you can break it up into a bunch of patents. So all that's fuzzy. So I think the first way to start worrying about this is to say, is there anything to worry about? Well, I've said, in my opinion, no. I challenged some regulators about how fast the rate of innovation is, how many companies are involved. They said it would be even better if it was regulated better. Well, how do they know that? They say that because they believe in what they're saying, not because it's rational. And the message, again, is if it works, why fix it? Now, one of the things you will have noticed is there are no dispute resolution rules in ETSI. There's a requirement to give the commitment to license on fair, reasonable, and non-discriminatory terms. But if there's a row about it, there are no rules saying you've got to go to arbitration, or you've got to go to ETSI body or not. Why not? Well, it's very simple. ETSI is an association of people, and you need a majority, I think, of 65%. Only one body, a regulator, has got a requirement of arbitration in its rules. I forget which one it is. It's not unimportant, but it's only one, and they've never had an arbitration. The reason, who votes against? And there have been votes in ETSI. Who votes against having an arbitration rule or some other dispute mechanism? It's not the implementers. It's not the major innovative companies. They would probably be in favor. It's the users. And that tells you something too. And again, regulators, if they were going to make the proposal, like the European regulator, they should go on to talk to ETSI and had these discussions, open discussions, so everybody could see what was being said. I don't think they've done that. And I'm afraid that there's a tendency amongst regulators, generally, because they're nearly all competition regulators, to be somewhat hostile to patents, thinking they are the same kind of thing that needs regulation. They are a limited exception, an unfortunate exception, which is a necessary exception all the same, but they should be confined. Whereas in fact, patents are something different, something quite different from the kind of thing that regulation was aimed at. So I think it would be a better world if we had compulsory mediation, compulsory adjudication process. What about compulsory mediation? Well, the European Commission proposed that. I'm glad to say they put it on the shelf for the moment. And let me explain why. Before I just do that, I should tell you my own experience of this system. In some ways, it's unique. When Nokia sold its handset business to Microsoft in 2011, the Chinese competition authority, then called MOFCOM, said, you no longer will need licenses because you don't make phones. It wasn't entirely true, because Nokia make huge amount of major equipment. The broadcasting equipment, everything you see up there is made by Nokia. Not quite, but a lot of it is on the top of poles. And but they theorized again, like competition authorities do, that Nokia would be tempted to raise its rates. Before that, of course, Nokia would have needed more licenses than they granted, because they were not a majority. Nobody's a majority holder of SEP lighters for any standard. And they said, you must be monitored. And I was one of the 2 appointed monitors to monitor Nokia's compliance with its obligations, along with a very distinguished China professor called Fang Yang. And we used to go and see Nokia every year, and they showed us all their agreements, every license, and explained the circumstances. So when I talk about how the licenses are actually in the real world, I know what I'm talking about. And I did it for about until 2022, because there was a later takeover by Nokia of Alcatel, who also had some SEPs, and there was a similar commitment. So the whole thing ran on from, I think, from 2022, 23, something like that. Now, what you notice is this. This is the real world. There are licenses between the big players. Nokia to Apple, Nokia to Samsung. Licenses back, because Nokia has so much equipment. The agreements were negotiated were not just SEPs at all. They were very complicated agreements. Sometimes there was a payment, a lump sum. Most of them were fairly short term, 3 or 5 years, something like that. Sometimes there were other business deals. So the big guys were coping quite well with each other. Of course, sometimes they didn't agree. Nokia's no secret about it. Apple, their license with Apple's license terminated, and Apple played difficult as Nokia saw it, and Nokia sued them in 16 countries, and then they had a meeting and settled it. Is that a problem? No. Do the competition people think it's a problem? Yes. Why is it a problem? Because it offends their sense of what ought to be. Because they are not working by evidence, by looking at what is actually happening. If the rate of innovation went down, there would be a problem. If it stays the same, there isn't a problem. If it's going up, there still is less a problem. So I think competition law doesn't need to interfere. On the other hand, there is the problem, which is this, that some courts regard a failure to enter into a license as almost ipso facto being a naughty boy, and they should be injunction. I'm particularly talking about the German courts. Partly because of their system historically never quite gets the fact that actually infringement of a patent and its validity are all part of the same question. They do it in separate courts for historical reasons to do with the foundation of the federal state of Germany. It is, of course, important that people don't hold out, and the holdout is real. And the only way I think, quite frankly, the major SEP holders have been too reluctant to sue. And it is very important that those who pay should not be faced in competition with those who don't pay. So if parties have been in negotiation for 10 years and then the patentee sues, the idea there should be then a 6-month mediation period when their action is stopped seems to me to be quite crazy, which was the part of the Commission proposal. Particularly, you had no idea who the mediators were going to be, what they could bring to the party that grown-ups couldn't bring to the party for themselves. The Commission's attitude is not repeated in other countries. There's been some repeat in China of competition interference. The Americans have backed off altogether and left it to the market. They too, some years back, wanted to interfere, which is the natural tendency of competition authorities to want to interfere. But I think the rational thing to do is to leave it where it is. Now, you've mentioned India's aspirations. I don't know they're merely aspirations, it's the reality. India is now taking the course which China took as a deliberate, conscious decision, as they're a more directed country than you are, that suddenly the patent system matters. And I think all Indian government efforts should be into enforcing, making that work better. If you compare India now, even with 5 years ago, the regard for patents is quite different. There are far more patent injunctions now, which are just impossible. And this system is perfectly suitable for India. And you will be, you say 2047, you will be a lot more innovative well before then. And that's what India should be looking at, is how to help our country become more innovative. And it is so difficult for competition authorities to understand that patents, although they stop people things, cause innovation. Jeremy Bentham said it in beautiful language. I'm not going to read it out now. In 1792, and he gave this message: if you don't really understand patents, you're naturally against them. If you do, you're so much for them that you think they should be property. It's in his private writings, which researchers at UCL are working their way through, and found that in 1792. Just the very beginning of the Industrial Revolution and the patent system, the Watt patent, and so on the steam engine. As a matter of fact, Sam Bentham, Jeremy's brother, got a patent later for making pulley blocks. You know what they are on a sailing ship? You have to have the ropes going around these pulleys. And a pulley block was made of wood and they wore out. And a big ship of the line would have 2,000 pulley blocks. And he invented a way of making them mechanically and built a factory at Portsmouth. Possibly, it was almost certainly, it was Bentham pulley blocks that were at the Battle of Trafalgar. So I say, leave well alone. And that's really my key message. I think we should have a discussion now.
Yeah, thank you. Thank you so much for a very, very lucid introduction and explanation of the problem, and the acceptance to the fact that it is a fuzzy environment, and as economists, we love the word the frameworks of asymmetry of information and discovering of markets, and in an asymmetric information situation. Uh, but you clearly have said that does not mean and that does not imply that regulators should intervene and try and appropriate a system which is not broke, appropriate a system and try to impose public order or public ordering or impose their values on a system, first of all, which perhaps they would also not understand. And so imposition of any public order would require, first of all, an understanding of that system. And so therefore, the current system, which is through the markets, the operation of markets, may be a bit litigious, but the clarity and the clarity or the establishment of the rights, so to speak, the private property rights, and the balance between which I discussed about between the holder and the implementer can be then left to the courts. So just with this brief summary, I would open up the discussion, and I would start with, I think, Ashish, you. So, and if you want to contextualize with what is happening in India, because normally policy is always made at the behest of or in the name of the poorer part of the deal. And in this case, the issues are that the SMEs and startups won't be able to navigate this extremely complicated system of licensing. And hence, license management should be, therefore, have some element of government intervention, where the government takes on the role of helping or providing a helping hand to these SMEs and startups. So what is your view, and how does India seem to be, and the Indian courts seem to be navigating this, and does it therefore require the kind of discussions which we are seeing, that there is a need of a helping hand by the government to these SMEs and startups?
Thank you, Payal. If I had very clear answers to both these questions, then the life would have been so easy. But let me try to break it down again, because I know some of the people who are participating or listening, at least some of our students here in BITS, may not have a very good understanding of the technicalities of the conversation. I know that Ashutosh and Sneha both have a front row view over how the litigation around SEPs is playing out in India. So it would be appropriate for them to comment on the legality and the process and the procedures and what to expect. I'm going to approach it from a slightly more general academic perspective. So first of all, thanks very much, Sir Jacob, for those remarks based on your paper. I suppose the fact that the Commission has withdrawn the draft proposals on SEPs addresses some of the questions that you flagged, some of the concerns that you flagged in the paper. But as Europe does frequently, they have used a language which has left many people quite confused. They say, citing no foreseeable agreement about the changes. So in my very limited understanding of having lived in the heart of Europe for a few years, I believe that means that another proposal should be tabled, but it may not be tabled, but it will try to be.
Yes, you're right. There are still there are some people trying to keep it going. I might even add this is largely driven by the German car manufacturers.
Right. Yeah, absolutely. So I think there are few more organizations outside the automobile industry that have been signatory to the letter which was sent to the commission 2 or 3 days after this decision was.
Yes.
There were 80 odd signatories to it. But you're right, in terms of the economic implications and in terms of the contribution to GDP of member states and of Europe as a whole, the automobile industry has significant heft. And
Can
I'm
I
not
just interrupt
surprised.
there? Because I just want to show how daft it is. There is a patent pool called Avanci.
Mhm.
Regulators don't like patent pools either, by the way, because they're all getting together to fix prices. Do you know how much a car manufacturer has to pay Avanci for a license? It's not for all the patents, not everybody's a member of Avanci, but over 80% of SEPs applying to 5G, which is what really matters in cars, are within the Avanci pool. Do you know how much they have to pay?
How much?
Have a guess.
€1?
No, this is for the life of the car. It's $29.
Okay.
And they're complaining.
Right. Yeah. Well, compared to the price of the car, that's definitely a very, very small amount. And that would have been one of my points as well. I was discussing with a student about Zoom and how suddenly Zoom became a common way for communication, transcending borders. Zoom uses the MPEG audio codec. Zoom also uses the famous H264 video MPEG codec. These are codec is short for coder decoder, and this is the technology that's responsible for the .mp4 extension to your files, and a lot of our files have that extension. The novelty of this technology is that it compresses data. AV files are compressed so that it's easy for us to move them around in emails and on pen drives and so on. Now, I was reading about this particular standard, and I found that variety of inventors and companies have been behind this spectacular innovation. They range from Bell, which is now Nokia, Fraunhofer, which is a German public funded institution in applied science. Max Planck is in pure science. Dolby, which has been at the frontier of sound and sound technologies, and they bring surround sound to us in cinema halls. Nokia, of course, a lot of South Korean firms, LG, KAIST, Korea Advanced Institute of Science and Technology, a bit like our IISc in Bangalore. A number of Japanese innovative companies that have contributed to the standard. NTT, one of the largest telecom firms. NEC, by the way, was responsible for developing color displays, and they introduced the idea of facial recognition to the world. Even Docomo, which is now NTT. Docomo, by the way, created emojis that we all love to use every day. And of course, Panasonic, which is a household name. And I was thinking that who in these organizations really contributed? Because while you asked, how does this compare to the current discourse in India? The current discourse in India at a policy level is how are Indian scientists and inventors contributing to the development of standards, STOs? Which means really representation in the right forums, at the right time. So with this list of organizations that I mentioned that are behind the MPEG audio video technology, I realized that there have been a large number of inventors and scientists they've been awarded more than 12, maybe 11 or 12 Nobel Prizes, 6 Turing Awards, hundreds of research papers in peer-reviewed journals. And it just seemed like a very daunting academic exercise to me. It didn't seem like a neo-capitalistic technology exercise. It really seemed like something we all do to get tenure track. And I started to draw an analogy with how things function in academia around the world. What do you look for? There's a certain trust underlying the system in academia, which of course is completely shattered in the case of uh, standards in wireless communication, which is why there is a bit of litigation, which is why there is so much of contrasting views even when the regulations were withdrawn. Some say that it goes against the vision of placing Europe at the front and center. Some say that it will boost competitiveness. Some say it harms the small, medium enterprises. Some say it is the only way to counter the Indo-China tech expansion. So I'm for one confused for sure. But in academia, we saw something similar. There's an element of trust underlying a system which has been functioning for well over 2 centuries. I am an author of a paper which may or may not pass muster with the editorial team of a journal, but I do submit it with my fingers crossed. And the journal then, let's say it's a double-blind peer-reviewed journal, the editor will pass it on to a reviewer. The reviewer will assume that the underlying data set or case law or survey result are not made up, not concocted. Now, of course, with Gen AI, we are questioning even that premise, but we'll not go there. But the reviewer is not questioning the sanctity of the data set, because the author makes a declaration at the time of submission. I make a declaration when I submit my paper that this is true and this is not concocted, this is not fraudulent, and this is not made up. Now, why am I making that claim as an author of my last draft, which I think is the last one, because I'm so naive? I will get a lot of comments back from the reviewers, I know that. I am confident because I've presented it in different forums, in conferences, in India, outside India, in workshops, on Zoom calls, in Taj Mansingh, in IIC. I've discussed my paper. I've sometimes even taken insights of that paper into a classroom where I'm teaching an elective, an advanced course. So there is a lot of thrashing out of that idea with different stakeholders. Then the reviewer who gets, I don't know who the reviewer is. I hope it's a friend, but we'll never know. It's double blind. This reviewer will also not question the qualification of the prior work of the people that I have cited. Although now with Turnitin, it becomes important to put the entire paper under check to see if certain references have been plagiarized. But there is a level of trust. And then finally, remember, I have submitted my paper to a journal knowing that this journal will do me well. It's not a mediocre journal. It's not a sham journal. It's not a predatory journal. It is a journal that has a reputation, and it has a sound editorial board, a robust editing process, and the publisher is indexed in global academia. I see analogies with the entire standard development process. The same exercise happens. People get together. It is a club, but so is academia. It is a club, we know that. And people try to, and with club, economists can bring insights that club goods tend to give to all of us through the literature and economics. But I did see these analogies play out very, very well. And with this in the background, I thought we need to dissect the issue. Where is the mistrust happening? Is the mistrust happening because people are simply calling a lot of patents essential when they are not? So that's, in other words, the problem of over declaration. Is that really a problem? I'm not a technical expert. Are they, and there is a claim chart mapping, and there are really sound researchers and experts who look into that. But I did read in the paper that the commission is concerned with the current licensing system, and they claim that it's fraught with inefficiencies and problems. And they have the draft kind of tries to address those problems. So first one, over declaration. I'm given to understand that the way ETSI and IEEE are structured as two standard development organizations, and Professor Jacob did mention that there are differences in how patents are identified in these two bodies. There is a fundamental procedural difference. In ETSI, specifics of patents and standards and section numbers are provided. In IEEE, which is the STO that covers the Wi-Fi standard, through which I'm able to have this wonderful symposium and connect to this call. ETSI follows a blanket declaration model where companies have to not only notify standards without indicating which patents they really have. Now, this means companies may own patents which are deemed essential to a standard, but a frank commitment is still required. Now, what's the outcome of two different processes of two different bodies? The IPR database that we see for ETSI does not indicate if a license is required for any given patent. The database is not even intended to be up to date in a real-time manner. It is never intended to be a repository of only essential, valid, unexpired patents that are needed to practice or that read on a standard. This is very clearly written in the disclaimer section of their IPR policy. So in some ways, if you think about it, both are encouraging inventors or patent owners to declare their patents to the respective bodies. What are these patents? The patents that might be essential. This is a very important question because there are
absolutely might be essential.
Might be essential. There are
if we don't know, and if they are valid, they might be essential. We don't even know they're valid. Do you know the portion of patents which are invalid wholly is difficult to measure. But one way of testing it is looking at the results of success of oppositions in the European Patent Office. In about 1/3 of oppositions, the patent is knocked out. In 1/3, it's upheld, and in 1/3, it's cut down.
Yeah.
Those are not necessarily the real figures, because those are the ones that are opposed. And a wise man never opposes an obvious bad patent. You hope that other people will worry about it and you don't.
Yeah, so you're right, absolutely right.
So all this is fuzzy, and the regulator thinks that's untidy. It's unhappy, and they're unhappy about it.
I'm saying that it's uniformly fuzzy.
Yes,
the difference. So
yes.
I suppose there is clarity required in the declaration process in both ETSI and IEEE, because at this point today, 29th April, 4:20 p.m. India time, 4:20 is just a coincidence. But it really is 4:20. Both the systems and processes encourage disclosure of potentially essential patents early in the process of standardization. The word potential is operative. The word early in the standardization process is what makes the entire framework very, very complex. I'll spend just 2 more minutes, Payal, then I'll stop. These two words, potentially essential and early in the process, have implications on the entire perception becoming bereft of any trust, opaque, or possibly making certain organizations think that there is information asymmetry. The starting point, as I said, with this Zoom codec, MPEG codec, the starting point is that companies do R&D, be it SME or a large corporation, doesn't matter. There is investment that happens into creation of a technology that may or may not result in a patent to be filed. Then, basis the process of patenting, SSOs deliberate, these clubs come together, like academic forums, let the best idea win. That happens. Then manufacturers start to invest quite heavily in the products because they have to. It's sunk cost for them. Then royalties are set. There is a contention here because for 4G, the royalties were announced prior to the deployment of the technology. So that part is a bit more fluid. And finally, there is competition that happens in the product market downstream. So if we're talking about automobiles, we'll have many smart automobiles that will have the 4G, 5G, 6G capability that will compete in the market downstream, and consumer is the king or the queen. Now, the problem is there is sunk cost investment, that's for sure. But sunk cost investments are being incurred on both sides. So there is a balance in potential loss that one can make. Sunk cost investments are being incurred by the manufacturer for sure. You can't go to the market in 30 days with 1 million handsets. There's a reason why, based on the PLI scheme, Samsung built that factory in Noida, and now they're one of the largest producers of handsets in the world out of that factory. It takes time. But there is also a lot of sunk costs that an inventor is incurring in R&D because the outcome is absolutely unknown. Pharmaceutical is a good example. Everyone's hoping for that blockbuster drug, but most of them result in duds. Now, the question is, and this is where economic literature comes in, if you know that there is sunk cost investment, then the ex post opportunism can come up. That's where hold up, hold out arguments arise. And both have happened in the past because there is a clear economic incentive, or as economists call, potential gains to be made. That the size of the pie is the same, and it's just in your interest to grab as much of it as possible. But I must say that there is a fair bit of uncertainty at every step of the way, right from the time when these R&D investments are being made. The manufacturer knows that something new will come up, but don't know when it's going to come up and in what form. There could potentially be, wherever asset-specific investment or asset specificity, as Klein Crawford say, there is bound to be some kind of opportunism. It's only human to be selfish. Irrationality is just a useful lie in the literature. You know that part. So then one can rely. So to this layer of the entire process can benefit from a bit more clarity and transparency in the interest of not losing gains that potentially one can make. And second is, what we know for sure is the end outcome of this entire process, which is what happens in the downstream market, that part is open and visible and measurable to everyone. And what gets measured gets managed easily. So we see the outcome. It's easy for us to buy these phones now. It's easy for us to uh, access some really advanced technologies with these devices. That's a reality. But I would not entirely disagree that the system is, uh, we'll be better off overall if there could be a bit more openness in how data is being used. I'll give an example from India, Payal. Indian Patent Office simply refuses to share data with EPO for INPA doc data set. That makes the representation of relevant, credible Indian patent information unavailable, inaccessible to researchers around the world. They could be PhD students sitting in India, PhD students sitting in Europe or somewhere else. It could be an industry partner. Now, you can always pay and get that information, but it is simply not getting transmitted from Dwarka to Munich. And that needs to happen. I'll stop.
Yeah. Thank you, Ashish. Good framework to think about the problem. And again, it boils down to, as you said, more clarity. But I don't think there is a doubt about that, because I think Sir Robin's starting point was about fuzziness. And economists also have done a lot of work about decision making due to uncertainty. And those kinds of models basically have not made a leap of faith and said that in the presence of uncertainty, the only solution, not that you are saying it, the only solution is that regulators come and clear this mess up. There have been other market-based solutions to clear this mess or to bring out more clarity, etc. And patent offices, private bodies are trying to get into this. And means when I was at Warsaw at this conference, so we do know that there is, and you people are in this business for a long time, that website by the name of friendly.com is trying to determine friend rates based on various parameters by plugging it into a model. So that was just my brief point, and of course, Sir Robin can also comment later. But before that, I would request Ashutosh, you have been in the courts. The problem is arising in this area, and why regulators seem to be a little trigger happy is that they are blaming the judiciary, and they are blaming the judiciary, for instance, in Germany, because they are quote unquote injunction happy, and so therefore follow-on innovations and downstream innovations get harmed. UK courts now, the interim license issue is causing problems to the SEP holders, because they are forced to accept a FRAN rate which they think will dilute their bargaining power. And now the litigation, this international litigation has moved a lot to the Indian courts. And Indian courts, do you think they're far more balanced? And do you think it will become a favored jurisdiction in forum shopping situations where there is a balance between both the SEP holders as well as the implementers?
So I completely echo the sentiments of Sir Robin Jacob on the point of when the system is working, why to fix it. And I also know I used to be a profound believer of that we should let the private ordering work, do its job rather than allowing regulator to start regulating each and every issue related with SEP and FRAN. But having litigated and handled SEP cases and FRAN cases for past 12 years in India, now I started thinking that maybe there's something which needs fixing. But unfortunately, all the regulators, and I'm not talking about the judiciary, our courts are doing whatever they can do depending considering what kind of resources, limited resources they have. It's the regulators who have kind of started this debate of regulating various issues pertaining to SEP and FRAND. And I think the debate was started in 2013 by the CCI when they passed the first investigation order and saying that the market competition is in danger. The competitive process may get affected because of the conduct of SEP owners. The investigation was started, and later on, the Delhi High Court set aside the entire investigation on the ground of lack of jurisdiction. 2016, the Patent Office floated a FRAND discussion paper, again highlighting the problem of royalty stacking, patent holdup, and now from 2023 onwards, we have DOT talking about sovereign patent fund, again raising concern of patent holdup and how it may affect SMEs and all. But in past 12 years, in all these 12 years, despite all these issues which are being highlighted by different regulators in India, the ground reality is something different. And that's why I say the regulators have got their diagnosis wrong. The problem is not what they are trying to fix. The problem is something else. So if you'll see from 2013 onwards, when CCI started this debate, till 2025, the competition in telecommunication market, in the context of which all this discussion started, has increased. We have 4 to 5 players, new players who have entered in the market during this period. Players like Xiaomi, Vivo, Oppo, Transsion. And from judiciary side, we have 6 judgments, 3 final post-trial judgments and 3 interim judgments. In all those 6 judgments, ultimately the court have came to the conclusion in 3 judgments at the prima facie stage and in the remaining 3 judgments at the final stage that there is evidence of holdout, not holdout. And 3 post-trial judgments, how long it took for court to decide? 2 cases were decided after passing of 9 years, and 1 case after passing of 13 years. And in fact, in the latest case, Justice Narula refused to go into the issue of FRAND by saying that because the conduct was so bad, that the implementer is unwilling licensing on the face of it, that I don't even need to go into it. So that's why I say maybe the fixing is required in terms of making the system balanced. Judiciary, as you asked, whether the judiciary is balanced in their approach in deciding and dealing with these cases. Judiciary is balanced, but the system is not balanced. Because as Justice Manmohan highlighted in his in-text judgment, there is a problem of judge population ratio in this country. So the system is already skewed in favor of a technology user, implementer. If they want to play the game, they can delay it as much as possible to avoid the liability. And the 3 judgments which I mentioned, the cases in which all 3 defendants, implementers, are almost out of the market or nowhere exist. Meaning thereby that the decree which patentee has right now is more or less a paper deal. So there is no fair compensation. The companies came, earned their share of money, and went out of the market. So coming back to the issue of what needs to be fixed is the system of this enforcing patent rights in India need to be fixed. We have to make it much more efficient rather than getting themselves involved or ourselves involved in the theoretical issues of hold up, royalty stacking. Until unless we see the concrete evidence of it, we should not invest our resources in dealing with this hypothetical problem, because we may end up creating a different kind of a mischief. And the issue of hold up and hold out is the best example of. Now, if I'm not wrong, and this theory of hold up and royalty stacking was started by an academic article published in somewhere in 2007, 2008. It was an academic concept, theoretical concept. Most of the regulators, especially regulator in US, jumped on it and started issuing guideline. There should not be injunction in SEP cases because of hold up and royalty stacking and all. Most of the regulators, then European followed, then Indians followed. And that led to the creation of problem of holdout, because it became much more difficult for SEP owner to enforce their patent in court of law. So if you'll start anticipating problem in particular industry, now in this context against SMEs, and start trying to fix those imaginary problem now, rather than solving that problem, you may create a new problem. And as I said, the system is already skewed in favor of implementers. Now, on this point of SMEs, because the recent discussion, which is about the sovereign patent fund, that we need to help SMEs because SEP may become a problem for them. And as Sir Robin Jacob has also mentioned in his article, that the alternative private ordering can be maybe the pledge by the industry that they won't enforce their patent against SMEs for a certain period of time till the time they become a big player and it become commercially beneficial to approach them for license. Now, the way I see, and I'm only saying from my limited experience about the Indian market, and that so far this pledge is being honored. This pledge may not be reflected in writing, but this is the kind of understanding with which the industry is functioning. In India, as far as my knowledge goes, none of the SEP owners have approached or litigated against any SMEs. So again, this seems to be rather a theoretical problem, and we are trying to assume a future problem and trying to fix it now.
Yeah. Thank you. Ashutosh, so my big opening remarks were that there is no empirical evidence when policy is being discussed. Policy is being made in the name of these SMEs and startups. And if you, we've just done consultations with few of them, at least in India currently, as I said, it seems to be that there is some cognizable problem or a cognizable market failure which has been identified, but it has not been backed by any empirical evidence. So it would be better, and having been in the competition law sphere for so many years, that you try and uncover the markets and the market dynamics first through some empirical evidence before creating regulatory rules or solutions. The example being that the Digital Competition Law or the Digital Markets Act has come after 10 to 12 years of solid evidence of the behavior of a handful of firms, which then required that some regulatory rules need to be put in place. So Sneha, sorry, I know you have been patiently waiting, and given your experience, the interface of IP and competition, not just we know, and Ashutosh has spelled out what has happened in the Indian courts, and it is still sub judice. The final outcome is will come when the Supreme Court pronounces its judgment. The little evidence, in the sense, little consultations which we have been doing as a part of our project. One thing which remains is that whatever it may be, the competition authorities will not be able to, because the even if it is not a holdout, even if it is a willing license or a willing licensor, but the problem is the price. It is the price and the failure of a negotiation on the right price. What is the right price that then leads to a process which may seem to be abusive from the perspective of the implementer, leading to, say, demands for injunctions by the SEP holders. But if prices and competition authorities shy at determination of prices because they have not even touched excessive pricing. Very few cases of excessive pricings have come up. If pricing is still not a thing which can be determined by a competition law adjudication, what role then does the competition authority, if that's the public law arm of SEP implementation, licensing framework, what role do you think, if at all, competition authorities have?
Thank you, Payal. And it's been really interesting to hear everybody. I think what is jumping out for me from Sir Robin's opening remarks to Dr. Ashish and to Ashutosh is, as lawyers, as people trained in legal studies, each of us know that there's a very basic principle of judicial review. If you pose a wrong question, you lead to a wrong conclusion. And I think each of us in our own ways are framing the question in the way we think best. So before I answer or address your question of what potential role the CCI could or could not play as the extended arm, I would want to present my reasons for certain reframing of the question that I would like to do. The first presumption that we're working on is there is no market failure, and therefore there is no need for an intervention. The question that I want to pose is market failure the only and sole reason why regulators intervene? To my understanding, the answer is no. There are many other reasons where there could be extremely healthy markets, well-functioning markets, yet because of certain government policy imperatives, a need is felt for certain policy interventions. For me, Payal, you just said a very interesting point about how there have been so many litigations as your role at the Competition Commission. You know, you're always looking at empirical data to
You
support.
said, forgive me, there is not so much litigation. The idea that just because you see litigation, nearly
I'm
all
not saying
SEPs are licensed without anything to do with litigation.
I'm not saying that at all, Sir Robin Jacob. Let me just clarify. When I say a lot of litigation, I mean litigation in the context of what is understood to be FRAND, what rates are coming. So I'll complete my thought. I'll just clarify the point that I'm making. Payal, you just mentioned that when as competition authority,
I'm wrong.
the role there.
Sneha, we are losing you. Either you may want to switch off your cameras. Perhaps it'll be a better.
So sorry, I think there's some issue. Am I audible now?
Yes. Yes.
Okay, great. So one data point that I would like everybody to consider is simply that, yes, we have not had so much of litigation, but in litigations where there have been assessments of FRAND's conduct and FRAND terms, what has emerged is a excessive, disproportionate differentiation between the initial offers and the FRAND rates. What that shows to me is that there may not be a market failure in the sense of how we understand market failure, but there is definitely a potential for market harm, because that extra money that so many implementers may be required to pay because they did not litigate could have gone into downstream innovation, could have gone into downstream investments, could have gone into downstream manufacturing facilities, et cetera, et cetera. So that's the first reposing that I would like to do. I think the first question to ask is regulatory intervention, market failure is the only reason or something else? To my understanding, non-interference by regulators for the reason of no market failure only achieves the objective of maximizing wealth. It does not achieve any other government policy objectives, which could be in the nature of just simply making technology available at fair prices. The second reposing or reframing of the question that I would do is, whenever we're talking about balancing an equation, we need to ensure that the two sides are identified appropriately. Otherwise, there would be no balancing. Now, in the equation that we are trying to balance today, we are trying to talk about reward to an SEP holder as one side of the equation and access to technology as the other side of the equation. I'm proposing a reframing of that question to what is the right that is of the, not what is the right, actually, the equation would be right of the SEP holder to be justly compensated for their patent having been adopted by the standard. That is one side of the equation. And the other side of the equation being the right of the innovator or the right of the downstream implementer to get a license on terms which are fair, reasonable, and non-discriminatory, and not work under a threat of an injunction, and therefore be able to focus on innovation. Now, the reason why I say this reframing is because when we talk about access as the part of the equation, to my understanding, the moment a patent is adopted as a standard, access is guaranteed. Because the moment an implementer chooses to adopt a standard or chooses to make his device standard compliant, he is accessing whichever patent is found to be essential, valid, and infringed. Now, obviously, there is this huge fuzzy area. Dr. Ashish has already talked about it. Sir Robin Jacob has already talked about it. I'm not getting into that. Yes, we need clarity in those standard setting processes for more transparency on essentiality, validity, and all those things. I'm on a point of access. I think what we're looking at is licensing for an implementer. I think implementers understand and they're not shying away from paying up money. What they are afraid of or what they are concerned about is that they are being hoodwinked. And that is where I agree with Dr. Ashish that where is the mistrust between the two equations? Because there is some mistrust, there is no balancing. That mistrust on the one side is happening because there is fear of holdout. That mistrust on the other side is happening that there is too much of payment being demanded. And that mistrust is, I guess, from both sides getting support from evidence that there have been instances of holdout and there have been instances of supra-frand royalties being demanded. Through judicial orders, we have found in some instances more than 80%, 90% was what the demand than what was actually found to be frand. So therefore, I think this mistrust will go when there is respect, when there is transparency, when there is one side of the equation focusing on licensing, paying money, establishing bona fides. I'm completely of the sentiment that nobody should not pay. That is not the sentiment at all. And I think implementers understand that. What they are concerned about is that they are being hoodwinked. So that's one side of the equation. The other side of the equation would be, we're talking about reward to the SEP holders. I think personally, an SEP holder has already been rewarded once their patented technology, essential, valid, has been adopted by the standard. That in itself is the reward. Once that reward has happened, there should not be an additional reward in the form of compensation. In the form of compensation, which is also catering to an additional form of extra higher value is what I mean. So I think the equation that we need to look at is balancing a right which the SEP owner has to get compensation. And absolutely, that is a right. Nobody should be denied of that right. And at the same time, what should be an implementer's way to ensure that they can focus on innovation, they'll pay the money, but they should not be threatened with injunctions today. Now, we all are talking about economies. We started with talking about forum shopping. There are potentially a few jurisdictions in the world where SAP issues are being litigated, but there is a significant amount of emerging markets where there is still a risk of an injunction. So I think what we're trying to solve for today is not just a jurisdiction-specific issue. While I understand we're looking at policy in India and we're trying to figure out if, what we can do to be a center of excellence by 2047, I think India this is also an opportunity to be at the forefront for policy in certain areas. Now, with this background, I think the three questions that you had posed, my views are private ordering in courts alone are not sufficient. In my view, there can be supplemental regulatory oversight or regulatory intervention, whether that is through legislation, whether that is through a regulatory authority, whether that is through additional undertakings by SEP owners to standard setting organizations. I'm not getting into which is the appropriate mean or institutional framework right now. I'm just simply on the principles that should be considered after reframing the questions on what should be the right approach. And I think that's where I would want to stop and
thanks, Neha. Of course, governments have a right to devise policy for access. So that's not something which we are debating. We are just then debating about efficient markets in the sense how to create efficient markets and therefore identify a particular market failure and bring in that instrumentality. When you get into the area of access and democratizing access, as economists, then we are in a totally different realm. We can socialize markets also. And we can socialize markets through regulation. So, but economic regulation does, this is just my own brief opinion, regulation does not look at socializing of markets. Economic regulation looks at instrumentalities of public law or regulations to be able to correct for the inefficiencies in the market and to be able to create efficient markets if private ordering and courts cannot do that through in a system. We do have because
Can I butt
yeah.
in? Because I've got to go soon. So I just want to comment on some of what's been said. The patentee is entitled to an injunction unless the person pays FAND. This is a property right. He's agreed that he will take FAND royalties and that he can have a dispute about that, but he's entitled to an injunction who's somebody who's messing about. And quite a lot of these implementers have done that over the years, particularly the Chinese ones. And if the negotiations have gone on for 14 years, then it's quite clear that it's being strung out. It's obvious as daylight. And what can the regulator do about it? What are they going to do? All regulation will interfere with the property right. It will mean less money for innovation for the future. Whether an implementer innovates or not, which was suggested, lots of implementers don't. They just make things as cheap as possible. Nothing wrong with that. But they've got to pay for the patented rights they use. I'm sorry I've got to go. I'm due to meet some people in Gray's Inn in half an hour. I didn't quite realise it was going to be as long as this. I'm not complaining because it's been very good fun. But I'm very sorry. I do have to go. I've got 4 German guests.
Yeah, so just we will just wrap up. Just one question from the audience, and then we'll just close. No, is there someone from the audience? Yeah. What is the question?
It relates to 3GPP standards and basically how they don't have their own IPR policy. So in India, they are governed by Indian standards in the IPR policy of TSDI. So has this been recognized by Indian courts? It's a question I think directed to Dr. Bharadwaj, but anyone can answer.
So, go ahead, Ashish.
I
No,
can't answer this question. It's a very interesting question.
I wanted to if Professor Jacob, if you have to leave, you can. If I were you, I would not keep a bunch of Germans waiting.
Yeah, you'll get an injunction.
Thank you very much. Thank you all very much. Fun.
Yeah, thank you so much. Thanks a lot.
Thank you.
Okay, bye-bye, everybody.
Bye. Thanks.
I unmuted myself to say hi to Eric.
Who is that?
The one who asked the question.
Ask the question. Yeah.
And for the heavy lifting, I'm going to defer to Sneha and Ashutosh. Has this fact been recognized by Indian court? I don't think so, but they should be able to elaborate.
Now you want to go ahead?
I think it has been mentioned that TSDSI does, like India does have an SDO, which is TSDSI, but the fact that 3GPP India standards are the TSDSI standards have not been dealt with by any court, is my understanding. Ashutosh, I don't know if you have a different...
So there, you're right. Actually, there are 2 judgments in which the existence of TSDSI has been recognized by court in Ericsson Lava and Index Ericsson. But what is the interpretation, what is the scope and purport of their IPR policy, that has not been discussed. So the center of focus will always be ETSI IPR policy.
Okay, I think I can perhaps...
Aman. Yeah.
I can answer this, perhaps not though in the context of a litigation that has already happened, because this was not, because in India, the litigation it's a suit, so it is between 2 parties. Whatever they are presenting before the court has to decide on that basis. However, in my general understanding, of course, that 3GPP standards in India are actually TSDI standards. There should not be any doubt on that aspect. However, whether they would be governed under Indian law or not is if the declaration was made by to TSDSI itself. However, what normally happens is most of the declarations are given before ETSI, and that is why the interpretation of French law is done. Even courts in UK have been doing the same. However, this is not a question that has been raised also before any Indian court of law, from my knowledge.
Yeah. So thank you, Ashish. Thanks, Neha. Thanks, Ashutosh. And thank you to everyone who has joined. There were 20 odds. I hope your students, Ashish, created the crowd. So good. Very esoteric topic, very difficult for people to understand. And so, but I think we were able to do some good today.
Can I, there, I see it's 4:56. Can I
4 more minutes.
Yeah, I'll take two. I'll take two, and maybe someone else can take the remaining. So, the Professor Robin said something about the price that one has to pay, and of course, that's a terribly low amount when you compare it to the end value of a Europe-made
For
automobile.
automobile, I believe, 1C royalty.
Yeah,
One C,
quite low.
$32 or $20 now.
I wanted to complete the loop of the example I took of these audio video codecs, MPEG codecs that Zoom utilizes, for example, the app that we are using. Now, a large VIA licensing is a pool, and it has big stakes in the MPEG standard that enables audio video. In last year, Samsung, this is in the news in media, so I hope it's correct. Samsung produced 120 million mobile handsets from its Noida factory. According to the rates published by the SEP owner via licensing, this comes out to for 75 million plus units, the royalty rate is 0.1 USD, which means that it's 8.5 rupees in an Indian context to be able to use this technology with ease. So that does kind of indicate that it's not an abysmally, it's not a barrier in any way. The other important point to keep in mind is, especially from when I speak with implementers, I have to use a slightly different grammar and vocabulary. But what I have come to realize is that one thing we patently forget is that getting a patent, the race to get a patent is open to everyone. So one cannot always be, one needn't remain fixed in one element of a very long, complex global supply chain and say, this is where I am, this is where I'm going to be, no matter what the other elements in that supply chain do. There is always there's always an option of catching up and to innovate and to take out one's own IP and then sit on the table with your own IP and try to negotiate and get the best deal. Now, this is easier said than done. We've also done a bit of exercise. It's not easy, which brings us back to the structural problems that we face in our IP system. But I just wanted to put this out, Sneha, since you mentioned that all the implementers are looking for is this and this, which seems quite fair. But given the larger aspirations and ambitions of the industry, of the government, and I'm sure this is a cross-political divide, there needs to be an attempt at some point to lead in the technology race, if not win it. You can't be complacent and always say, I'm going to sit at the back with and wait for cruise control to kick in.
And in fact, few of the companies you will see now started creating their own portfolio, and a lot of Chinese implementers are part of patent pool as well. Now, what is the quality strength of those portfolio? That's debatable, but they have started creating. So what you just mentioned, Ashish, no, I think a lot of implementers are also thinking from the point of view to jump to the other side and to be the technology creator. And I'm sure, no, a lot of people, the debate would be different then. Yeah. When Chinese implementers will start enforcing their own patent. In fact, I can tell you, give an example that I attended one court proceeding in Munich. And in that was a SEP case. In that case, the defendant was a German company and the SEP owner was a Chinese company. So things are changing. You never know.
Yeah, very well said, Ashish, because that's also, and we couldn't discuss because this is very, very India specific. If India aspires to be a developed nation, and so rather than go with a begging bowl for innovation and knowledge, we should be knowledge creators. And yes, it is easier said than done. It requires a huge structural transformation into the innovation ecosystem. But if at all the role of the government is if there is kind of a positive externalities as we use in the economics jargon coming out of research and development in creation of standards and then also technologies that we read into those standards, it is here where the positive externalities need to be harnessed with government support, that is helping institutions, helping academicians, because you brought in the analogy of academic papers and people who sit at these standard setting organizations when they are presenting their technology to be declared as a standard. There are people, there are PhDs from universities like MITs, etc., working in commercial outfits and commercial outfits like these large companies, which we
But
are.
Payal, very few are actually participating in these forums that I was talking about. That's where really the rubber meets the
Yeah. So
road.
that's what I'm saying. So India needs to then up its ante and create. So there are a handful of engineers in IITs who are doing this. So India needs to up its ante and support an ecosystem which will just boost up the innovation rather than going with a begging bowl and saying, give us free or give us cheap or give us at no price. I mean, I'm not slighting the frictions of the system. There are frictions in the system which you have pointed out. But from a policy perspective, we have to see where we need to tilt. Whether we need.
Just to add on that point, Dr. Malik, know about our own innovators from IT and all these institutions. Apart from the fact that to promote innovation at all these institutions and also in the Indian organization, we also have to kind of improve our system of improving the opportunity for them to monetize that kind of invention to inform through licensing and to enforce that. And this was, in fact, one of the objective of 2015 IPR policy that India will promote monetization of IP and licensing of IP. Unfortunately, that has not been, no concrete step has been taken towards that.
Yeah, so hope to meet again, all of us, and hope to continue with this discussion. Thank you, Sneha. Thank you, Ashutosh. Thank you.
Thank you, everyone.
For the Payal, for the next one, next year, 2026 will be 100 years of the merger of General Body and Fisher Motors, which was at the heart of the paper that you were referring to, Klein Crawford and Alchain. Next year is going to be 100 years since this monster was released by these scholars. And rest is actually history. The merger did happen and Williamson got a Nobel Prize, and the three solutions became quite popular in the economic literature. But maybe we should come together and collaborate for a symposium only in the memory and everlasting legacy of Hold Up, Hold Out.
Sure, and a few more webinars from ICRIER, but at intervals of 2 months or so. We hope to see you again.
Wonderful.
Thank you, everyone. Thank you, everyone.
Thank you so much. Thanks.
Thank you.
Bye.
Thank you.